start. Welcome to our latest webinar, this time on housing allocation schemes, their review and revision. You are going to hear from both myself, Tara O'Leary and Sarah Salmon. Could I ask you, if you have any questions during the session, that you put them on the Q&A rather than the chat? It's just so that it's easier to know that we've answered them. And there will be a chance at the end, after Sarah's session, to ask a few questions and hopefully answer them as best as we can. Can I also remind you that we have the Housing Day, the annual Housing Day, in person for the first time in 3 years on the 5th of October at Gray's Inn. And I understand from our marketing people that there are still a few places left. You can see details on our flash new website, which you hopefully can navigate because it looks really impressive. So please feel free to do so if you can and make it there. There's lots of good speakers and lots of good topics, many of which have been suggested by previous participants. Anyway, I think it's probably best not to have me rambling on, although we have got a few more participants in because of that. And we're going to start off with Tara, who's dealing with the first part of today's webinar. Tara.
Hi, thanks very much, Andy. Good morning, everyone. It was really lovely to see so many familiar names on the register today, but also just to see so many names. And I know all three of us are really pleased that so many of you have taken the time to log on and join us this morning. So I'm going to kick things off just for a short section to provide what's effectively, for most of you, I suspect, a refresher about the architecture of the legislation that deals with allocations. So if Andy will take me to the next slide. Again, I'm mindful that this is probably well known by many of you, but it's useful, I think, just to remind everyone exactly what we're talking about when we talk about allocation. So the definition of this comes from the Housing Act 1996, Part 6, as does really all the legislation I'll be referring to. And that actually gives us a statutory definition of allocation. So first of all, selecting people to be secure or introductory tenants of accommodation held by a local authority, fairly straightforward. What people might forget is that it also applies to nomination for introductory or secure tenancies of another local housing association or authority, excuse me. And I think probably that's most likely to happen in circumstances where you might have a number of local authorities getting together to pool their accommodation or to set up some sort of special scheme for certain classes of people, for example, victims of domestic abuse or something like that. Thirdly, nomination to be insured tenant of a registered provider, such as a housing association, which is very much an everyday occurrence for local authorities now. And fourthly, I think this is one that might have escaped perhaps some people's attention, which is that if existing secure or introductory tenants of local authorities want to transfer to different accommodation, their cases are also considered to be allocation and therefore caught by the provisions of Part 6 and by local authorities' allocation schemes, if they are a person who would fall into a reasonable preference category. Now, I'm going to talk about reasonable preference more in a moment. Effectively, those are the people who are prioritised by Part 6 of the Act. But I think that's quite an important thing to point out. This is something that stems from the Localism Act, which I'm also going to mention in a moment. But the idea is that if a person has a reasonable preference, the fact that they're an existing tenant doesn't mean that they are necessarily prioritised above anybody else with a reasonable preference. They have to be treated in the same way and in accordance with the same rules. And of course, what's very important about that is allocation schemes and Part 6 of the Act do not apply to any tenants who do not have reasonable preference. So that's usually people who want to downsize or want to move accommodation for some sort of other reason within the district. And many local authorities are not constrained by Part 6 and so will have set up some sort of separate policy or transfer scheme to help people move, like Home Swapper or so on. So that's what we're talking about for the rest of this morning. If Andy just flicks back for one moment, you can see to the previous slide, Andy. Back to the first slide, Andy, in the other direction. seem to be having difficulties with the slot.
That may be beyond my technological ability.
Okay.
Let me just see if I can do that.
Apologies to everyone.
Yeah, what I'm going to do, I'm going to start it again. That's always the best way of doing it.
The dangers of technology. Thank you. Sorry about that, everyone.
We got there in the end.
I was just going to point to the quote at the bottom of this slide from Lloyd Norberger in the case of Ahmed. Effectively, what you can see when you look at these categories of people who are caught by allocations, this is the gateway allocation schemes to a precious and dwindling public resource. People who get access to social housing get access to stable, good quality and low cost accommodation, potentially for the rest of their lives. It's a huge deal. Anybody who is allocated local authority housing gets access to the right to buy. And I think obviously there's always going to be fierce competition and room for some really intense disputes about allocation of those resources. But it's also worth pointing out that the allocation scheme is a really important tool for local authorities to actually try to shape the communities that they have in their districts and to make sure that they are livable, attractive, prosperous communities that are enjoyable to live in and have a mixture of different tenures and different sorts of people living together. And particularly in urban areas, you can imagine that's obviously a matter of massive concern to elected members and their constituents, and therefore for the officers and solicitors, particularly in local authorities, who are trying to help them implement those goals. So now moving on to the next slide, one at a time, Andy. Turning to the statutory architecture itself, we're concerned with Part 6 of the Housing Act 1996. That came into force in April 97, and there were some pretty substantial amendments in 2003. And what that's left us with is effectively this structure, which is what we're dealing with. So there's firstly a broad discretion to local authorities to allocate their housing in such manner as they consider appropriate. Now, that gives them an awful lot of power, and that's an extremely broad and open-ended discretion. But it is, I think it's important because it sets the tone for what local authorities can do with their allocation schemes, but it obviously is subject then to various constraints imposed by the Act itself, as well as by various pieces of statutory legislation. So, first of all, we see the requirement to operate an allocation scheme. Effectively, that's also a requirement to operate a housing register where people have to sign up and all applications gathered together. There's also the crucial requirement to provide reasonable preference to persons. Now, they're spelled out by section 166A, subsection 3. They are homeless people, people who are owed the main homelessness duty. So that means they would be homeless, but for the fact that they're currently sitting in section 193 temporary accommodation. People living in overcrowded, insanitary conditions, whether in council housing or in the private sector, and people who need to move on medical welfare disability grounds, or people who need to move to a particular locality in the district because otherwise it would cause them particular hardship. I suspect there's significant overlap there with disability because there will be people who are vulnerable and need some sort of intensive in a particular location. There's then a discretion to provide additional preference for certain people who have reasonable preference if they have urgent housing need. And so most local authorities schemes, for example, will have a distinction between people with medical priority versus people with urgent or emergency medical priority. So people who need to move in the medium term versus people who, for example, can no longer access or leave their homes unless they're moved to level access accommodation pretty quickly. And then there's a very broad discretion, finally, to distinguish or prioritise or discriminate within the categories of people with reasonable preference, having regard to 3 specific factors. So their financial resources, that's their ability to pay the rent. You might see that translated into a requirement that anyone, for example, whose income is over a certain level may be disqualified, for example, on the basis they should be expected to pay for their own accommodation or more expensive accommodation elsewhere. The person's behaviour and suitability to be a tenant, that's obviously including histories of ASB, but also often rent arrears. So if somebody is judged to have had the resources to pay their rent, but not doing a very good job of that. And then finally, the big one, which is local connection. And I think you're going to hear a lot about local connection for the rest of this morning, because that's really been one of the thorniest issues over the last few years, and comes up repeatedly in the cases that make it to the High Court and the Court of Appeal. So thank you, Andy. Next slide. What then happens in 2011 is very substantial changes are introduced to the Act by the Localism Act, back in the salad days of the Tory government, when they were all still young and fresh-faced and no one had ever yet heard of Liz Truss. The quotations I've set out here are taken from statutory guidance. There's a number of different guidance documents, but this one is allocation of accommodation guidance for local housing authorities, published in 2012, but it's been continually updated as recently as June this year. And this describes the aims of the Localism Act as threefold. Firstly, to give housing authorities power to better manage their housing waiting lists by giving them the power to determine which applicants do or do not qualify for an allocation. Now, that was a huge change at the time, because the previous legislation had imposed quite a lot more constraints on what local authorities had to do in respect to reasonable preference. Those were torn up. And the idea was that, subject only to some minimum requirements, local authorities should now be free to choose for themselves how they were going to manage their waiting lists. Secondly, making it easier for existing social tenants to move by removing the constraints of Part 6 from those applying for a transfer other than those in reasonable preference. And I've already discussed that on the first slide. So this is the source of that, which is if you remove everyone who's not reasonable preference from Part 6, it frees up local authorities to come up with their own priorities, particularly to facilitate downsizing. And then thirdly, maintaining the statutory protection of the reasonable preference criteria. So the clear subtext here is autonomy and is local decision-making with regard to local circumstances. So you can very much see the clues in the name of the Localism Act itself. How did it do that? Well, the Localism Act brought in what I would call three broad categories of amendments. The first was this very broad discretion introduced by what was then the new Section 160ZA, and that is a broad power to designate classes of persons who can and crucially cannot qualify under the local allocation scheme. Now, that's massive, and what that allowed local authorities to do was effectively to just wipe out whole groups of people from their local schemes, or to introduce special priority for whole groups of people. Obviously, having regard to varying extents to their personal circumstances, but very much being able to sort of put them into certain boxes and very clearly set out how they would treat them in certain ways. Now, that broad discretion is subject to three exceptions, which were actually legislated in terms of the 96 Act itself, or supplementary regulations issued under the 96 Act. Now, those three exceptions were immigration, as is also the case under Part 7 and homelessness. People who are still asylum seekers or who have other sort of restricted forms of immigration status are excluded from the provisions of the Act. And what the Act does is it basically says that local authorities do not have any power to decide to create a class that could, of asylum seekers or immigration applicants who can benefit from the scheme. So local authorities don't have any power to sort of opt into allowing them access to their local housing. They stay in a separate regime accommodated by the Home Office. The second and third categories work the other way. So what they've done is they have the 2012 provisions and regulations and the 2015 regulations. They're the qualification criteria for armed forces and the qualification criteria for right to move England regulations. And what they do is they prohibit local authorities from disqualifying people from their housing allocation schemes on the basis that they don't have a local connection to the area if the applicants meet the definition of what's called relevant persons. And there's now two categories of relevant persons. The first is to do with the armed forces. So current or former serving members who basically need to leave their MOD accommodation due to illness or disability, which has arisen because of their service, or their spouses who've been bereaved because they died in active service and who therefore need to find alternative accommodation. They need to be treated as, or deemed as, having a local connection. The other category of people, perhaps a little bit more controversially, were applicants who are already social tenants of another area. They're in work, they have a reasonable preference, and they want to move to your district to access employment opportunities. And so again, if they're moving for that reason, to get closer to a job or a workplace, local authorities are not allowed to treat them as not having a local connection, and effectively have to give them some degree of preference as a result, because they'll be treated more favourably than others. Now, there are some important pieces of statutory guidance which encourage, some might say strongly encourage, local authorities to grant other forms of preference using this broad discretion. The most important is victims of domestic abuse, under a new piece of statutory guidance that Andy is going to talk about in a moment. But importantly, the statutory guidance doesn't mandate local authorities to do that. So there's no requirement, for example, to grant priority to people suffering domestic abuse who fled to your district, but you're encouraged to do so. And I've highlighted those three that I have because they're the only ones that are mandatory. So that's the first category of Localism Act amendments. The second is that discretion is counterbalanced by the right to seek a review internally about any decisions on whether or not someone is qualified and how they fit under the scheme. And that often operates in such a way that there's a right of internal review. And if the person isn't content with the outcome of the review, that's the point at which they start to consider judicially reviewing in the courts. And then the third point is that, which I've already mentioned, which is the removal of Part 6 from applicants for transfer who do not have reasonable preference. So those are really the big amendments brought in by the Localism Act. And then what we see over the last 10 years is what happened when these changes began to be made. Now, it did take quite a bit of time for individual local authorities to start changing their schemes to use these different powers and discretions that had been granted to them by the Localism Act. And so this is not something that happened overnight, but something that started to filter through over time. The first, I think, effect which was seen and felt by a lot of applicants on the ground, people seeking housing, was a fairly bumpy transition when new, more stringent allocation schemes were introduced. The broad powers to designate whole classes of people who no longer qualified for allocation meant that more or less overnight, in some districts, very large numbers of people were summarily removed from housing registers. And that was often because local authorities decided that they would effectively remove people who had very low priority. Many local authorities introduced local connection residency requirements, so you had to have lived in the area for a certain number of years. So anyone who didn't meet that was booted off the register. And other sort of criteria which were meant to sort of effectively remove anyone who had a very, very little chance or very low chance of being allocated housing, either anytime soon or at all. And that was a way, I think, to help realistically manage applicants' expectations and to get numbers down on the register. But it did mean that quite a lot of people who may already have been, as they perceived it, waiting on the list for several years were bumped off and were very unhappy. And there were reports that the complaints about allocations to the local government ombudsman mushroomed in the years after the Localism Act was introduced, while these changes filtered through the system. The second kind of immediate, and obvious implications of the Localism Act are that there's going to be a huge variation between different local authorities, district to district, what the qualifying criteria will be. It's a bit of a postcode lottery in some respects. I think people often think of that in terms of the difference between inner city districts versus rural areas, where clearly completely different sorts of considerations will apply. But to give an example from London, my own home, which is not rented from a local authority, is located in the London Borough of Islington. But literally the end of my street is the beginning of the London Borough of Hackney, and happens to have a block of council flats right there. So if people who live only about 100 metres away from me would be subject to different qualifying criteria. And it might also mean that if, for example, I had to move flat because I was renting and I moved only one street away, I might lose my local connection qualification and my residency rights to the London Borough of Islington. So you can see there will be many cases where these hard rules and bright lines can create, frankly, some difficult outcomes for individual applicants. The third outcome is the very obvious, very strong shift in emphasis to local connection as one of the defining qualifying criteria that's necessary to get allocation of housing in England now. There is a piece of statutory guidance, which I've cited there, providing social housing for local people. And I've picked out a few choice quotes from that, which is that the government of the day was of the view that local authorities should ensure they prioritise applicants who can demonstrate close association with their local area. Sufficient affordable housing must be available for those, emphasis amongst the local population on low incomes or otherwise disadvantaged. And the Secretary of State believes that including a residency requirement is appropriate and strongly encourages all housing authorities to adopt such an approach. And the Secretary of State believed a reasonable period of residency in the district before you qualify for allocation would be at least 2 years. So short of actually putting all of that into the legislation itself, that is about as strongly worded as statutory guidance can be. And as a result of that, many local authorities understandably have seized the day and introduced some fairly stringent requirements on making sure you have a connection to the district before you're allowed on the housing scheme. What that's then kind of gone hand in hand with is my fourth point, which is blanket disqualifications. So anyone who hasn't lived in the area for 2 or 5 or 10 years, do you need exceptions to mitigate those rules, and what should those exceptions be? And you'll see this is strongly flavoured the case law that Andy and Sarah are going to talk about it. I've just pulled out these 3 cases as quite clear examples of that. Hillingdon had a 10-year residence requirement before allocation, which was obviously quite stringent. Miss Ward was an Irish traveller, Mr. Gulu was a Kurdish refugee, and because of their history, background and lifestyles, neither of them could satisfy that requirement. And the Court of Appeal eventually ruled that that was indirect discrimination. It indirectly disadvantaged people like them. And on the evidence available at the time, Hillingdon hadn't provided sufficient justification to explain why it could not create exceptions for people like that. But it was open to Hillingdon to come back later with better evidence, which Andy Lane represented Hillingdon in that case. So I suspect they have now done with his advice and assistance. Ealing was a case involving our colleague Wayne Beglin from Chambers. And that was one where Ealing had a 5-year residence requirement. HA was a victim of domestic abuse who had fled into Ealing from somewhere else and argued successfully that effectively there should be exceptions for people in her situation. And so you'll see that really a lot of the case law comes down to these hard cases and the extent to which a balance needs to be struck between competing interests. So that's it for me. I will hand you over to Andy.
That's excellent. Thank you very much, Tara. And I also ought to say apologies for my voice, which is getting worse this week, but hopefully it'll hold out. As you've heard, Tara has been dealing with the allocation scheme, how its present setup has come about, and in particular, the discretion afforded to local housing authorities by the Localism Act of 2011 and the amendments to Part 6 of the Housing Act 1990 scheme that it brought in. Sarah's going to be dealing with the methods of change, and I'm going to discuss some of those issues that inevitably arise from seeking to change or even just seeking to think about change. I also ought to just say, in terms of the Hillingdon case, I was led by Kelvin in that, and obviously great credit must go to Kelvin for all the hard work he put into that case. But it did bring up a lot of issues to do not just with the indirect discrimination question, but also the public sector equality duty as well. But looking at the reasons for change, well, for some authorities, and it may be hard to believe, but there are some authorities that still haven't changed from their pre-Localism Act reforms. And therefore, they still have many people on their schemes who, frankly, are not in housing need. And one can have a debate as to what is an appropriate scheme and who should be given priority. But there's undoubtedly the case that prior to the changes, there were lots of people on the schemes who didn't need social housing. And I could have gone on to my local authority scheme prior to 2011. So it was just a nonsense in that sense. But of course, it has thrown up a lot of questions which have arisen because of the discretion now afforded to local authorities within the parameters of the Part 6 scheme. Also, of course, it hasn't been that long since the reforms. It's now 10 years, and authorities will have learned from experience, and indeed their aims will have been reviewed. And of course, if they want to prioritise particular needs, whether that be local connection or whether that be those in low income employment, or whether that be people who are carers, then of course that's the kind of thing which is going to make them think that perhaps a change is needed. And that follows on with, of course, the different prioritizations and qualifications that are needed or wanted, and of course the requirement for consultation to that end. Local letting schemes, which I'll come on to in the forthcoming slides. In other words, looking a bit more bespoke at certain properties and how those are being let. And the treatment of reasonable preference categories, which Tara mentioned, which again, I'm going to look at in a little bit more detail in one of the later slides. But effectively, many local authorities, and we know from the response to this webinar itself, that a number are actually looking at their own schemes as things presently stand. And of course, although not required, it makes sense to see how the scheme operates, to see that it operates fairly, to see that it meets the requirements of that particular local authority. So looking at, again, qualifications and prioritisation, we actually have a number of strategies, some of which Tara has already mentioned. But of course, we also have before that the need for any local housing authority to comply with its own strategies, internal strategies. And in particular, we have the homelessness strategies, which would have been provided under Section 1 of the Homelessness Act 2002. We'll have had the current tenancy strategies, which will have been provided under Section 150 of the Localism Act of 2011. And we'll have had, as you can see there, for London housing authorities, the London Housing Strategy document that would have been provided by the GLC. It's probably not the GLC anymore, is it? That's taking me back. But those are the strategies that would have to be looked at, and compliance would need to be ensured so that there is a coherent strategy that's been provided. Guidance, of course, has been provided on certain issues. You have overall guidance that's been provided, but you have in particular had guidance provided by reason of Section 169 of Part 6 for allocation to local people. You can see at the second bullet point, provided in December 2013. Of course, it does say 2 years, but it's important to remember it says 2 years at least. And there was an argument in the Hillingdon cases as to that meaning. But of course, it is, as it says, it's merely saying not that it should be 2 years, but it should be at least 2 years. If you want it longer, of course, you need to be much more careful in terms of the impact on people and whether it still remains fair and whether it still is in a position to say that it doesn't discriminate. Domestic abuse is actually a document that was provided in 2018. The January 2022 date is the updated provision. And in broad terms, as indeed was put in the local connection guidance, it really encourages local connection requirements not to cover those people who are fleeing domestic abuse. And of course, domestic abuse there is being given its widest meaning. It's also, of course, in any decision as to what qualifications to provide. Because remember, as Tara has indicated, you have the statutory eligibility, which is an immigration question, and then you have a whole host of possible qualifications, the most obvious ones being housing need and residency requirements. But of course, in any of that, you need to consider the questions of Equality Act discrimination, in particular, Section 19, indirect discrimination, although pausing there to say that I was involved in a case with Matt Hutchins of Z and Hackney, which was alleging direct discrimination in parts in relation to parts of the stock in that area. But also, of course, public sector equality duty issues. In the Gulu and Ward cases, Lord Justice Lewisham had indicated that there wasn't a problem initially because there was no reason why the local authority should have been particularly aware of the questions, in particular of the Irish traveller issue. But certainly once they've been made aware, they should have been alive to the problem and should have at least considered how that impacted upon their proposed 10-year requirements. That also, of course, means that other public law duties are inevitably involved, including Section 11 of the Children Act of 2004 and the best interest of children. I have to say, it's probably something that is not going to be the end game, that's Section 11, whereas the PSED is a much more likely issue to trip up an authority, which is why, of course, anyone going through a review of their allocation schemes will have to be fairly good when it comes to equality impact assessments and when it comes to knowing the figures and knowing the details of the impacts of various schemes. So, for example, in a residency qualification, what's the difference between having a 2-year scheme, a 5-year scheme, a 7-year scheme, a 10-year scheme? Clearly, there's going to be differences and clearly there's going to be impact. What is that impact and can it be justified? The last bullet point I've put on here is not only because obviously everyone at the moment in housing is talking still about El Kundi and Imam, but because it is potentially important. Just very briefly, those were cases which confirmed that the Section 193 full housing duty owed to those homeless who are eligible in priority need, not intentionally homeless, and with the local connection. Those people are owed that duty, which is an immediate duty. One can't say, I'll house you in a few months because I can't find anything at the moment. It's an immediate duty. And really the question is, in that case, what should the courts do if a judicial review is taken against a local authority for not providing suitable accommodation under Section 193? Well, that's a matter that's going to be maybe dealt with by the Supreme Court because permission has been sought. But one of the concerns is that Lord Justice Lewis, who gave the main judgment in that case, was looking very much at the question of, well, why don't you use some of the stock you presently use for Part 6? Now, that's not suggesting that there be any queue jumping or any automatic prioritization, if one wanted to formalize it. But what it was saying is that you could provide, for example, non-secure tenancies from local authority stock and stock which ordinarily you would be using for Part 6 allocation, thereby reducing it. And what he said, and I just quote from a part of his judgment, paragraph 134, is that it may, for example, have a number of properties that it would like to use for allocating to applicants on its waiting list for Part 6 accommodation. It can be expected to explain why it's not using those properties to ensure that its Part 7 duties are met. That is not to say that the local housing authority must make a final offer of secure tenancy of accommodation to a homeless person. Rather, given that the duty under Section 193(2) will continue and may be met by the provision of accommodation on a short or long-term basis, an authority may need to explain why it's not using its housing stock to secure accommodation that is suitable on a non-permanent basis to meet its Part 7 duties. Now, we know, as Tara has said, that the homeless, both statutory homeless and non-statutory homeless, are to be given a reasonable preference anyway. And this judgment, in a sense, is outside that. But it does really go towards the stock available to a local authority, which may have particular pressures to find suitable accommodation for its Part 7 duties, in particular Section 193 and the full housing duty. In terms of local housing schemes, and this is something that you will see in the Act under Section 166A, subparagraph 6, and that allows the allocation scheme to contain provision about the allocation of housing accommodation to persons of a particular description, whether or not they are within subsection 3. So, for example, if you had a particular new stock come online, you could decide that you wanted to use that for existing residents who are in already in local authority or social housing accommodation. That would be a local letting scheme. There is guidance on this, which you'll see from the primary guidance of 2012, the allocation of accommodation guidance for local housing authorities in England. And it's also worth noting from the case that you see at the top of this page, C in Islington, that Mr. Justice Baker, who was looking at a scheme which included a local lettings policy, which had been introduced some time previous to that in 2013, under which if new homes were constructed on existing estates, then the authority gave priority to residents on those estates, so very similar to the example I just gave. And what was determined in that case is that the local lettings policy within a local authority's housing allocation scheme unlawfully discriminated against victims of domestic violence and therefore women, contrary to Article 14 in conjunction with Article 8. However, the discrimination was justified on the ground of proportionality because it struck a fair balance between the severity of the consequences for a social housing applicant and the importance of the legitimate aim pursued by the policy. So an interesting case in many respects, but it really focuses on the fact that if you're going to have a local letting scheme, one has to be very careful as to its extent, as to its purpose, and as to its impact. Whilst it's still up in the air as to whether the convention actually applies to allocation schemes, because we're talking about people bidding for properties, not people actually having properties, it still, of course, raises questions of discrimination, not least the Section 19 indirect discrimination to be found in the Equality Act of 2010. And I think lastly, for my bit, is just a few cases on the question of reasonable and additional preference categories. I started here with Montero, not only because this was one of Matt Hutchins' cases, but also because a lot of local authorities have said to me in the past is that if we have restrictions, for example, on people who have committed acts of antisocial behaviour, by which they have had injunctions against them or possession orders on ASB grounds, are we allowed to disqualify people in reasonable preference categories? And the answer to that is quite simply yes. One has to be very careful as to how far one goes. If you look at the other extreme at the bottom of the page, Jakimovic, that was a case where, from recollection, it was people in 193 accommodation, so being owed the full housing duty for homelessness purposes, were in accommodation. They were taken out of the scheme, and that was deemed to be unlawful. But there is certainly no reason why, for example, if you have a residency requirement, that wouldn't apply to those in the reasonable an additional preference category as much as anyone else. Again, one has to look at the figures to see whether there is any particular group which is being discriminated against in those provisions. And when Tara mentioned the fact that the Localism Act was given a discretion to local authorities, this has to be seen in the context of what an allocation scheme is. And that's why I've mentioned the two cases in the middle. In the case of Crown and Wolverhampton Metropolitan Borough Council ex parte Watters in 1997, it made it clear that it's a head start that's being given. In other words, it's not a guarantee. Just a cite from Lord Justice Judge, the statutory obligations imposed by Section 22 therefore requires that positive favour should be shown to applications which satisfy any of the relevant criteria. To use colloquial language, they should be given a reasonable head start. Thereafter, all the remaining factors fall to be considered in the balancing exercise inevitably required when each individual application is under consideration. If, despite the head start, the housing authority eventually decides on reasonable grounds that the application for a tenancy must be rejected, this will not constitute a breach of the obligations imposed by the reasonable preference categories. And Lynn simply said, and this is an authority often cited by local authorities in judicial review actions, that reasonable preference doesn't equal success. And as Dyson said in that case, it is quite possible for a scheme to be lawful and a person with reasonable preference never to be allocated Part 6 accommodation. They're entitled to no more than reasonable preference. And that also means that one may have a situation where groups outside reasonable preference are given extra preference. It's a question of justification, and it's a question of being able to show that it meets the aims and is not discriminatory. But in those circumstances, one can do so. So in summing up, what I would simply say for anyone looking at reviews of their scheme, you need a good equality impact analysis. You need the figures. You need to know how your changes will affect matters. And you need to know that you have a fair degree of flexibility, but that should be used in keeping with stated aims, which you can justify the actual provisions when it comes to prioritization and qualification. So that is all for me. And I'm now going to be passing on to Sarah. Sarah.
Thank you, Andy. Yes, so I'm going to be looking at changing your scheme. So most local authorities, local housing authorities will already have their scheme set up some time ago. And as set out on the first slide, Andy, if we can go to that, there's actually no statutory obligation to keep the terms of your allocation scheme under review or even to revise a scheme regularly. But you'll see on the slides that I've set out that the codes of guidance there do suggest it's good practice to keep policies under review. In addition, local authorities will have to think about revising or potentially changing their policies in certain circumstances, which again are set out on the slide. So changes to legislation, there may well be changes to legislation, and we've heard about the changes to the Housing Act 1996 from Tara earlier on, that do require local housing authorities to look at their schemes, revise them or replace them. There's also decisions of the court, but the decisions of the court are twofold. So it's not just talking about decisions of the court in relation to your particular local authority scheme. It's also that you have to look at decisions of the court when they are assessing other local authority schemes. And in fact, in a 2017 report, the local government ombudsman said it would criticise a local housing authority for failing to review its scheme in response to a court judgment that dealt with a scheme of another local housing authorities if those matters were relevant to its scheme. In addition to that, you've got to remember that usually before there'll be any challenge to your particular scheme, you're likely to get a pre-action letter of some sort. So it's good to try and assess early on, even under the threat of litigation, whether or not your scheme is operating as it should do and whether or not there should be any revisions to it in light of a potential challenge. And then we've also got changes to statutory guidance, and you've heard about some guidance from Andy and Tara, but there are also 4 codes in England. So you've got the Social Housing for Local People Code, the Right to Move Code, the Domestic Abuse Code, and the Armed Forces Code, which all encourage local housing authorities to review their existing policies and revise them if appropriate in light of the guidance. So you have to keep on top of the guidance and keep your allocation schemes and policies in mind. And then of course you've got events which happen on the ground, and the 2 most obvious events in more recent years, obviously Grenfell, which led to changes in terms of allocations that were required in such an emergency. And of course, we've had we're still in arguably the COVID-19 pandemic, which may impact on allocation schemes. So you're deciding to change your scheme, whether that's in its entirety or whether it's a revision. And where a local housing authority proposes to make significant changes to their scheme, 2 statutory requirements come into play. First, and Andy's already mentioned it, we have the impact assessment, which is necessary to ensure that you're not only complying with equalities legislation, but also any of your own equality statements or policies. And secondly, if there's a major change of policy, then you may well be you will be required to notify and consult. So I'm going to take the first one of those in this slide. And when it comes to the Impact Assessment and Equality Act, the primary focus is likely to be on section 149, which is known as the Public Sector Equality Duty. I am aware on our website, I think there are links to webinars that are solely focused on the public sector equality duty, and of course I don't have time to go through it all today, so people can go back and watch those if they need to. But we know from the case law that is built up in relation to section 149, both in the housing arena and also other areas of law, that it's not a tick box exercise, it's a matter of substance, and it's not purely a formalistic exercise. So it is important to give proper and correct consideration to the public sector equality duty. And in the complaint there that I've set out, the East Lindsey District Council complaint that we see, that was a complaint where the council's executive board had approved changes to the allocation scheme without even having sight of the equality impact assessment that had been completed. And the Ombudsman found that that should not have happened and made a recommendation that actually you have to go back and review your scheme having regard to the public sector equality duty. So not only have you got to carry it out, you've then got to ensure that it's taken into account when you're reviewing and looking at your allocation scheme. As you'll see there as well, I've listed 4 cases. There are more, some of which have been mentioned by Andy and Tara already, but the courts have considered the P.T.S.R in relation to allocation schemes. And I'll just highlight a couple of those there. So in the C and Islington case, that was a challenge to a local letting scheme, and that challenge failed. And it failed because it was said that the local lettings policy was part of the whole of the allocation scheme. And when the whole of the allocation scheme was being introduced, it went through an extensive analysis in relation to the sorts of issues that crop up under the P.T.S.R. And so the defendant local authority had that due regard under the public sector equality duty. In H and Ealing, which is a case again that I believe has already been touched upon, but the courts made comments in an allocations context that this wasn't a precise mathematical exercise, and a relatively broad brush approach may be sufficient. And that word may is obviously quite tricky because it plainly highlights that in some circumstances broad brush approach may not suffice. So you do have to act with care when looking at section 149. And finally, in the Hillingdon set of cases, which both Andy and Tara have touched upon, just focusing on the P.T.S.R and focusing on the challenge by Mr. Gülük, who was a Kurdish refugee. In that case, it was held that the local authority hadn't done anything wrong initially in relation to P.T.S.R, but by the time the claimant had brought the challenge, there had been, once the claimant had brought the challenge, there had been a breach of the Public Sector Equality Act duty by failing to consider the position of non-UK nationals. That's just the focus there on the P.T.S.R. The case also did say, however, that the P.T.S.R did not oblige the local authority to assess the potential indirect discrimination effect on every conceivable group that would have a protected characteristic. So if we move on to the next slide, the other thing that will be important in terms of impact assessment will be discrimination more broadly under the Equality Act. So we obviously have Section 29 of the Equality Act that prohibits discrimination by a person providing service to the public or exercising a public function. We also have Section 33, which I'm sure will be known to delegates, which prohibits discrimination in the disposal of premises. Now, in relation to both of those sections, there are a variety of protected characteristics that are caught, including disability, gender reassignment, race, religion or belief, sex and sexual orientation. And under Section 29, there's the additional protected characteristics that is caught in terms of age, although that doesn't apply to somebody who has not attained yet the age of 18. And of course, you can have indirect and direct discrimination. And with disability, of course, Section 15 provides a particular type of discrimination, which I'm sure you're all familiar with. And that is the type of discrimination where a local housing authority could seek to show that any discriminatory treatment is a proportionate means of achieving a legitimate aim. In addition to all of that, if what is happening under the rubric of a service provider or exercising a public function, then the local authority will also have duties to make reasonable adjustments. And that's why I've included the case of Nor on this slide by way of example, because the court held in that case that the local authority was a service provider or exercising a public function, and so was subject to a proactive duty to make reasonable adjustments when operating its bidding system. Now, also on this slide, you can obviously have discrimination under Article 14 of the European Convention of Human Rights, but that only engages if it impacts upon the enjoyment of a convention right. And that's why we see there Article 8 with a question mark. And there's a question mark because it's not entirely clear whether Article 8 would be engaged in these types of cases. There were several cases some years ago now, back in sort of 2015, 2016, where the High Court accepted that Article 8 would apply. But then in 2007, we got H&E Lynn, where the Court of Appeal cast some doubt on that. But the question arose again in Z, which of course Andy has touched upon as a case he was involved in. But in the Court of Appeal actually rejected that the policy fell within the ambit of Article 8. And it was Lewisham, Lord Justice Lewisham, who made the point that what the court was dealing with, what the court was concerned about, was the ability of somebody to move home. So there we had a person who was housed, albeit not necessarily satisfactorily, but was housed and wanted to move to a bigger home. When it got to the Supreme Court didn't have to decide the point, but what the Supreme Court did do, and it was Lord Sales who gave the leading judgment in the court, he expressed reservations as to the Court of Appeal's conclusions. So it's still to be determined how Article 8 really works and sits alongside allocation policies and schemes, and how discrimination arguments might be successful using Article 14. So when I started this section of my talk, I said there's two things. You've got your equality impact assessments, and then you would have to notify and consult. Well, you have to notify and consult if there is to be a major change. So that begs the question, and the question you would have to ask yourself is, what is a major change, and is what we're doing a major change? There isn't a great deal of guidance on this. The Welsh Code of Guidance sets out any amendment affecting the relative priority of a large number of people being considered for an allocation, and any significant alteration to procedures. So that's what the Welsh Code would say would be a major change to an allocation scheme. There's a couple of cases on the slide as well. In the Brent complaint, a major change was a change in policy under which working applicants were awarded an additional 5 years priority. So that was a major change that would have engaged the need to notify and consult. But in A, we see a slight contrast. So the case of A and Lambeth, what that was considering was a change to the proportions of allocations, so something which was sort of deemed quotas, if you like. So the proportions of allocations which were made available to certain groups. In that case, though, the quotas were not actually part of the original published scheme. So whilst in that case, other aspects of the scheme were actually held to be unlawful, in terms of the change in quotas, it was held that that didn't constitute a major change of policy. So that's an example of something that wouldn't be a major change. Other examples I've set out there might be quite obvious. If you're moving from an officer-led allocation to at least some choice-based allocation scheme, and also if you're moving from points to bands in terms of awarding priority, and that's something that can be seen. I'm not sure if it's on a slide, but there's a case of Farrer against Southwark where you can see that that was a move and that was a major change. So you are carrying out a major change to your policy, and so you have to carry out a consultation. So I've set out there on the slide some of the things that local authorities have to do. And in terms of consultation, it's advised that local authorities take the broadest possible approach to consultation. So in terms of housing associations, of which a local housing authority has nomination agreements, you would send them a copy of the draft scheme and you would give them a reasonable opportunity to comment upon that. But in terms of the community more generally, there are a variety of things to consider. So in terms of the first bullet point, what I'm getting at there is it's the requirements in your statutory scheme for consulting current tenants. So you need to look at those and you need to comply with those. And you also need to consider any expectations that the regulator has in relation to consultation and participation by tenants when bringing about major change to policies. You also need to ensure you bring it to the attention of those that it affects and take such steps that are reasonable. So the most obvious are applicants that are currently being dealt with under your current scheme. And one of the easiest ways to do that, assuming you have contact details for those, which you should have, would be to send them correspondence detailing the change. The slightly more difficult part of the community are potential applicants and the public more generally. And local authorities will be used to this, and they have usual mechanisms of bringing it to the attention of those types of groups. So you have obviously your website, local newspapers, providing information to local advice agencies, and so on and so forth. So those are what you have to do in relation to consultation. There are other public law duties you have to think about when you're changing the scheme. We've heard about domestic abuse and we've heard about other matters from Andy, which I don't repeat. So I just highlight two here, and there's not much more to say than what is set out on the slide. So you have section 11 of the Children Act, which is of course a duty to safeguard and promote the welfare of children. You need to take that into account. But there's a recent amendment to the Armed Forces Act, which does set out that a relevant function is a housing function. And when doing that, you have to have due regard to the unique obligations of and sacrifices made by the armed forces, the desirability of removing disadvantages from those sorts of people, and the fact that special provision for those who have served in the armed forces may be justified. And so finally, I am coming on to think about other considerations, and one of the trickiest aspects often of adopting extensive amendments to a scheme, as to how to deal with those who have been assessed already under your current or what will be your old scheme. And here's the FARA case I touched upon over in the last couple of slides. You need to make it clear in the scheme, and in the FARA case, the court said it wouldn't plug the gap. And in that case, the new scheme was silent as to how applicants who had already registered under the old scheme would be dealt with. And the change to the scheme in that case was priority was going to be given on the basis of date of registration. And essentially, the scheme would have to be revised, because if such provision was to be made for applicants already assessed, then it should have been dealt with in the scheme. And then I just emphasise the need, when you're dealing with people who have already applied, to deal with things in a timely manner. And that was brought out in that complaint that you see on the slide. And it was said in that when reassessing priority, where a new scheme would result in an existing applicant being treated differently, it should be dealt with in a timely manner. Now, that may well be obvious, but obviously when you revise schemes and looking at the number of applicants you may have, it can often be overlooked that you have to potentially reassess those already on your scheme. So when you do change your scheme, you also have to put in provision to make sure that that is dealt with in a timely manner. So that ends my section of the talk. So we're open now to questions. We're bang on time, actually, 12:03, which has taken an hour. I think some people have asked some questions in the chat function, which have Q&A function, sorry, which have been answered. Thank you for Tara there. Oh, and Andy, who seems to have answered some more questions. So I think it's for me to thank everyone for attending.
We have a hand up.
Oh,
Francesca.
I can see that.
I don't know whether people have volume capabilities. I don't know whether they're disabled when they come in, which often happens on webinars. If somebody wants to put it in either the chat function or the Q&A, if they have a question, if they can speak and they can put the volume button on, please do so.
It's been enabled.
Ah, lovely. Thank you very much. Francesca. You're on mute at the moment, I'm afraid.
Okay, can you hear me now?
Yep.
Oh, good. This question actually goes to Sarah. In regards to consultation, do you have a time frame for consultation? How long can one consult with the community or the private providers?
As set out in my slides, I think you just have to give a reasonable time for consideration and response. Andy, is that right?
Yeah, I mean, I think it's got to be something you can justify. I mean, if for example, you said, it's going to be on our website for 3 days, one may take a view. But if somebody says, no, we made it quite clear over a 4-week period, various bits of publicity went out to say that we're changing the scheme, then I think, you've probably done enough. I think, just try and be realistic, I suppose. And normally these things, of course, are going through committees and so on within the local authority, and therefore there's no need to really kind of not do a proper consultation where it's required. Because remember, if it's not required because it's just a bit of a quick change, it may well be something that doesn't require consultation anyway, which you can do. But yeah, I think being realistic is always the best idea. And when you look at most local authorities, they've given probably 3 or 4 weeks time for people to respond with their consultation responses.
Is there a legal obligation to actually consult with the communities?
Well, as Sarah said, only when it comes to major changes.
Major
So
change.
so if you were going to introduce some, let's say, a new qualification category, or if
Yeah.
you were going to suddenly change from a 2-year residency requirement for, or let's be optimistic, 15 years, then I think you would need to consult. There are other changes where perhaps it's less important. Let's say you just add an exception to a qualification requirement. Let's say you add a domestic abuse exception. I think in those circumstances you probably don't need to consult, but it does depend.
Right. Finally, on the domestic abuse issue you've just raised now. So are you saying that do they come under the priority group? The domestic abuse, there's no legal requirements for them to come under the priority group at all?
No, Francesca, I addressed that in my section. So there's guidance which sort of strongly encourages introducing an exception, and I think the case of HA and Ealing shows, you know, that was even before the Domestic Abuse Act came in, which would probably add kind of further encouragement. And that shows what would go wrong if you sort of refuse to consider even a one-off exception in an individual case. But no, there's no statutory requirement, and there's nothing in any statutory instruments. So even if a local authority does decide to create an exception, it still has a lot of discretion as to how it would do that in the context of its particular scheme.
Thank you so much. Thanks.
Which, by the way, and it does remind me, one of the issues that some local authorities get wrong, or arguably get wrong, to be fair, is the clarity of their scheme in parts. It's got to be clear. Now, I know that there was authority on this, one of the Birmingham cases, by way of example, but yeah, one needs to be clear as to what one's doing. In other words, it shouldn't be open to interpretation. It should be abundantly clear whether one is entitled to fit within the exception or get the prioritization. So one has to be very careful with the wording and make sure that that is done legibly and in a very clear and unequivocal manner.
Brilliant. Thank you so much. Thoroughly enjoyed it. Thank you so much.
Thank you very much.
Thank you so much. Appreciate that. Yes.
Anyone else?
I think it's lunchtime. People must be getting hungry.
This will also be on our websites. We also.
Are you gonna email the slides to us?
Amanda.
Are you going to email the slides to us?
I don't know what we normally do, but I'll check that out. But we can do, I'm sure.
Yes, the recording will be available.
Yeah.
Thank you so much. I appreciate that.
Amanda?
So overall, the allocation scheme should give reasonable preference to those in the reasonable preference categories. Although we have the option to do local lettings policies, how would you interpret the word dominate the scheme in terms of numbers?
Yeah. I would do it over 15 pages of an advice. To be honest with you, it's a difficult one, isn't it? But in a sense, if somebody's just arguing, you know, the effect. I mean, let's take an example I've seen, right, where people have put the homeless in a category, the bottom category, who virtually never get the properties. You know, just the figures show that they just never get them because they always go to the 4 categories above. One may take the view then that one isn't being given reasonable preference, and that, you know, other groups, whether in or out of the reasonable preference categories, are taking preference in an undue manner. But even that, to be honest with you, is arguable. I mean, I've had that argument, by the way, in relation to that example. And of course, for a lot of local authorities, they have had PRSO strategies to try and use the private rented sector to deal with their Part 7 obligations. But of course, there is that mismatch, I think, with the allocation scheme sometimes. And I do think it is quite a difficult one, really. But I think if you are focusing on a particular group, which may or may not be a reasonable preference group, that is fine, so long as reasonable preference groups are in the mix, if I can put it that way, and they're not shoved off into a bottom rung where, let's be blunt about it, they ain't going to get anywhere. They're probably going to be accommodated in the PRSO or other accommodation before they ever get anywhere near social housing. But as I say, everything's arguable. But that's the obvious example I can think of at having a separate category in a letting scheme where it's effectively the bottom category. And I have seen that, which has made it very difficult for them to actually bid realistically for any properties. Have you guys come up across anything? Tara or Sarah, have you?
Not particularly, no. Sorry.
Sarah, have you? Is there anything you've? I mean, are you thinking about something in particular, Amanda, or is it just a general kind of
No,
concern?
we have a number of local letting schemes to try and achieve a particular policy objective.
Yeah.
And we've got one going through at the moment, and we're looking overall in terms of, you know, how many properties overall are being allocated to reasonable preference categories. Yeah. And we've come up with a number, and I'm just sort of trying to interpret that number into dominance.
Well, to some extent.
Is it 1 in 10 or not more than half, or 7 out of 10, or, you know?
The important thing that you're doing, to be quite frank, is you're doing the figures. And that's a big plus point, because it makes you aware. It's clear that you're having regard to the issues. And of course, when you look at the local letting schemes individually, you know, they may well be compliant because they may well fit within your aims, which are set out, and there may be a very good reason for it. But obviously, at some stage, as you're doing, you have to stand back and look at the scheme collectively. But you're not required, for example, to do the figures as to which of the reasonable preference categories get accommodation, but it's probably a sensible thing to do, because at least then you can say, look, we're very mindful of the fact that these are reasonable preference categories, and that therefore, you know, we're looking as to how many actually get accommodation. But the last thing I would say is that, remember, reasonable preference to some degree is saying you get on the scheme. A lot of people don't get on the scheme. Yeah, they don't qualify because of questions of residency or questions of housing need or whatever. So to some extent, merely getting on the scheme could be seen as a reasonable preference, which is why I'd be cautious about worrying too much about whether it's 40% or 20% or 70%. I think, you know, if you can, you know, demonstrate that those people in those, you know, section 166A3 categories are being given, you know, priority in the scheme, doesn't have to be the top priority.
Thank you, that's helpful.
I'm mindful that we've now run quite a bit over time, and I know that some of us have other commitments elsewhere this afternoon. So I think probably what we can say, and we often say at the end of a webinar, is that if there are any other questions which come up, please do drop us an email. If you can't find our addresses, our clerks are always available, and we'd be more than happy to sort of answer anything and follow up outside the webinar, if that's helpful for anyone.
Could I just say, Tara, that Mark has asked a question on the Q&A, which, just to say, is there an expectation that major amendments to policy need to be considered by the local authority committee following consultation, or would sign off by a senior position suffice? Well, that depends on your standing orders, to be honest with you. You don't want a constitutional battle like you often get with, you know, farming out the review functions in homelessness. Check your standing orders. In principle, there's no reason why that can't happen if your standing orders / constitution allow for it. Do you guys agree?
Yeah, that's what I would have said. Yeah. Check your constitution. Right.
And we've also just had a comment from Victoria. Highlight reasonable preference for those in relief and prevention duties. Yeah, I mean, absolutely. I mean, in fact, the reasonable preference groups, remember, go wider than just those people who've applied as homeless. There are people who haven't even applied as homeless, but who are homeless, who are treated as reasonable preference. So it's quite a wide category. But you're absolutely right to say that it's not just the 193 duty cases.
Yeah, I think that's interesting, actually, because of course the Part 7 has been amended substantially since the Localism Act amended Part 6. So that might change the interpretation of that provision of Part 6.
Yeah. Okay.
Thank you. Thanks a lot.
Preta waits.
Thank you all very much.
Thank you very much, everyone.
Yeah, bye.
And we look forward to seeing you at Housing Day in October.
Yes, that'll be good. Thank you so much. Yeah.
Okay, all the best.
Bye.
Bye-bye.
Bye.